Court officer, court officer, court officer.
ಸರ್ ಲೈವ್ ಸ್ಟ್ರೀಮಿಂಗ್ ಇದೆ, ವೇಟ್ ಮಾಡಿ.
Application for posting my this is filed in application for posting.
But committee Lord has passed an order
Without
in respect of Metro Lord. Metro rail, Lord, three cutting. My lords have already directed that there must be a committee Lord constituted. Committee goes into it. Committee's report based on that Lord, we have placed it before your lord. Approval Lord, on the last two occasions Lord, my lords have passed a similar order. Same order has to be passed. Permitting us to.
This is an application, no?
Yes, Lord, its application is pending.
I hear for the petitioner.
I one of 2020.
The matter was listed on 6th April for hearing of 6 applications that were filed. Lord, on that day, the matter has been adjourned to 22nd of June.
That is
I
because
number
Lord,
7.
Sorry, my apologies.
I number 7, my lord, has been filed by BMRCL to advance the matter. That is I number 7 that has been listed today.
On the last occasion, what happened was, Lord, I was held up in another court. He asked for a, Lord, instructing was asked for a sort for a Passover. That was, Lord, therefore, Lord, your lordships were busy that day. Every day, Lord, 2 crores, Lord, is the loss that we are occasion to us. And, Lord, that the pre-committee, Lord, has already held, Lord, if your lordships turn to, Lord, IA number 1 of 2020. The expert committee reports that we.
Hey, now we have to post it matter. Okay. That's right. We have to list the matter first.
On 9/2, my lord, your lordships have passed similar orders, my lord.
I file my objections to these applications. I number 1 and I number 2 of 2022. It may be posted, my lord, for hearing on all these applications. From I number 1 to I number 6 of 2020.
Date लगा देते हैं कुछ अभी date लगा देते
Subject to my court's
All right, we will have the matter on day after tomorrow.
As your lordship.
Accepting the reasons, IA 7 of 22 is allowed. Relist on so on. Day after.
Day after tomorrow.
Prevention of cow slaughter.
Yes.
office objections with regard to PL and amendment of petition is not carried out.
But I am here, Lords, with one request. Of course, on the main matter, Lords, it may take some time. We have filed an application, IA number 9, Lords, the kind of state. IA number 9, Lords, wherein, Lord, we are seeking modification of Lordship's order. IA 9,
Yes.
the background is this. When the validity of this act was called into question before this court, we had not framed the rules. Section 5 provides for us to initiate penal proceedings against any person who transports cattle without permission. But since rules were not framed, this court restrained us from initiating any further prosecution proceedings in respect of all those persons who
Our rules have been framed.
Now we have framed the rules. That what we are requesting Lordships to take them into consideration and permit us to implement the rules. The rules are very elaborately framed now. Lordships may kindly have a look at the rules itself. Along with our statement of objections, Lordships may quote of statement of objections. It's in WP 1695 of 2021. Kindly see this.
This order of 20th of January, you want to.
20th of January, there is one sentence there. Lordships get the order of 20th January. But the Lordships have the order of 20th January.
Yes.
In that, Lordships will kindly see. The learned advocate general appears for the states and takes notice. The learned advocate general on instructions states that till the rules framed in exercise of powers under provision section 5 of the Karnataka Prevention of Slaughter and Preservation of Cattle Ordinance are brought into force. No coercive action shall be initiated by the state government for the breach of violation of section 5 of the state ordinance. Thereafter, act has come into force. We have framed elaborate rules. What happens, is we have prevented cow slaughter, but people are transporting the cattle from one place to another place for the purposes of cattle. One of the main mechanism of preventing is to prevent transport from one place to another. Now we have framed rules, and it will not apply to transportation by farmers within 15 kilometers radius.
Now you want to enforce the rules.
Yes, we want to enforce that. That is the permission.
This much is to be clarified.
That's that.
I have objections to the same. My objections will kindly be taken out. My submission is this, my lord.
What is your objection?
My objections have been placed to record in WP 9501 of 2021. My lordship has it?
Yes.
My objections are very simple, my lord. At the outset, we have challenged the very constitutionality of the Act. My lord, my submission is that the implementation of these rules in question would effectively allow for the implementation of the Act, which has not been considered, my lord. One of the main grounds which I have taken up in my petition, at the outset, my lord, the petitioner herein in this case is a community organization of Dalit members. It's for the upliftment of Dalit society, my lord. The Dalit community, my lord, which is the petitioner, has approached this honorable court in challenging the provisions of the Act in view of especially 29, Article 29 of the Constitution, which is an article, my lord, of
All right. The validity of the rules itself is under challenge. That is to be considered finally.
Yes, my lord. Just one provision I would like to take you, my lordship, to, my lord, which is
Order which 20th of January 2021 was passed at a time when the rules were not framed. And in the order itself, it is provided that the state government will move this court so that the petitioner are put to notice that the rules are likely to come into force. Now the rules have been framed. All this is under consideration before the court.
I submit, my lord. One of the challenges made by me is lack of legislative competence. In any case, my lord, Article 304 of the Constitution specifically provides that prior permission of the sanction of the president has to be taken in a case infringing on the freedom of trade or commerce or intercourse. My lord, this is an act which specifically falls within that provision. Now, falling within that provision, the old act, my lord, had taken the prior permission of the president, my lord. That is mandated under Article 304. We have raised very severe challenges, my lord, to the constitutionality amongst
No justification when the rules have been framed. That is the only ground. There is no justification. All right.
It may be considered together with my interim act, my lord.
Learned Advocate General, appearing for the respondent on the IA 9 of 2021, moved by the respondents. The petitioner has filed its objections. The Learned Advocate General submits that the order dated 20th of January 2021 was passed at the time when the Karnataka Prevention of Slaughter and Preservation of Cattle Transportation of Cattle Rules 2021 were not framed.
Or if I
The
may additionally submit, my lord, the conditions which have been imposed upon by these rules, my lord, they are extremely onerous, my lord. For transportation, even from one place to another, I have to take prior certificate
all right,
and various requirements.
It is submitted that the undertaking was given when the enactment was not made. Now, subsequently, the Karnataka Prevention of Slaughter and Preservation of Cattle Act 2020 was enacted with effect from 15 to 2021. Thereafter, by notification dated 24/5/2021, published in Gazette on 25th May 2021, the Karnataka Prevention of Slaughter and Preservation of Cattle (Transportation of Cattle) Rules 2021 are framed, referable to the rules contemplated under Proviso to Section 5 of the Act. Now the state government wants the permission of the court to implement the provisions of Section 5 of the Act and seeks the indulgence of this Honorable Court to modify the order dated 20th of January 2021. Full stop. Counsel for the petitioner submits that the petitioners have challenged the validity of the the Act itself, and the competence to enact any such act. The implementation of the Act and its rules would cause great prejudice to the several sections of society. Full stop. We have considered the submissions. The validity of the Act is under challenge, which is under consideration before the court. Since the rules have been framed as such, the order dated 20th of January 2021 is required to be modified to the extent that the state government is permitted to implement the provisions of Section 5 of the Act and
the rules.
and the rules made thereunder.
If I may be permitted to make just one more submission, my lord.
However, the same would be subject to final decision
Yes.
in the writ petition.
I'm appearing for respondent number 2 to 5 medium.
Yes.
Copies were not submitted, my lord.
No, you have not fulfilled the requirement of Rule 14. Rule 14 of PIL rules.
Non-prosecution.
Dispatched by the registrar in view of Rule 14 of different.
Previous matter connected.
Sure.
41.
Calling of order. Okay.
By this rule, registrar has dismissed the non-comprehensive officer objection.
We amended 2 years back.
ये क्या करना क्या है?
Recall करना है, set aside करके.
Where is that order?
Resolve.
This is here. Now you are ready to file the translated copy. Where is that? Have you brought the translated copies? See whether translated copies have been filed. Translated copies, he says, he is already filed. See, there is no translated copy.
Not yet. Not yet.
Then it is filed.
You bring it, we file it, only then we'll recall the order. List again after summer holidays, summer vacations. List again after summer holidays.
Pertaining to transfer. Under the transfer guidelines, in 2 years of service, if 2 years of service remain for superannuation, in that period there should be no transfer. Is the transfer guideline of the policy of the state government. What they have done is that page 100 and page 109.
Where is this Nana Jyoti Nagar? Where is this area where she is residing? She has to come here, right?
Yes,
Transfer is not very far away, within Bangalore.
correct.
That's the reason the learned single judge.
Ah.
One issue here is not kindly see the
Kempegoda Road to Ruputunga Road.
but one issue is
Road is changed.
Road is.
kindly see the transfer guideline.
No,
Rabbi, first tell me what prejudice has been caused within this same district.
But I would not have been upset but for the notice.
Cost.
There is
so this cost will waive.
The only thing,
this cost.
on,
There was a letter by an
you
MLC.
cannot insist for a particular post.
I'm not insisting.
Then
This would not have happened but for a letter.
it is only the post which you want to hold.
No, but I'm not insisting on
Ah.
that. One issue here is why I was upset was, why I was dislodged was, there was a letter given by a MLC.
It appears that deputy controller account is a very lucrative.
No, but
Engaged senior advocate, president of the bar.
but I,
You can submit your lordship before she was got transferred to the place where she wants now. She got a letter from the Chief Minister M.A.D. Siddaramaiah. From that she has got call.
what has happened here is,
कुछ है
the exciting point of why I was dislodged.
all those things whichever if at all, is violative of some transfer policy or some guideline, that has no mandatory force. It is only the guidelines. The transfer policy are only the guidelines. You cannot challenge an order simply because it is contrary to the transfer policy. Transfer policy has no mandatory force.
Issue here is that but for the letter by an MLC saying that I should be removed and another person should be put there. That letter, I'll just read it. It was
No.
given before the learned single judge.
Annexure?
That annexure is not there. Memo was given before the learned
Where you have taken
There's no
this plea
reference.
before?
Can I just
There's no reference to, either it has to be an annexure or there has to be a reference to that letter in the learned single judge's
Single
order.
order.
learned single judge says that.
It shows that where?
Learned single judge had summoned those papers.
Correct. Where is the reference to that letter?
The Learned Judge has proceeded on the basis no injustice is caused. She has completed 3 years. Though her term is only 2 years, she has completed
No,
3
she has
years.
not completed 3 years.
No, yes, I have
She had
given a date.
completed 2 years, 1 month.
No, madam. She has completed because she is working there from 31/12/2019 even also. 22
The
to
letter is-
2019 she is working. And when she was trying to be replaced, she files a writ petition. This court allows the writ petition. All that is
Learned single judge only
3 years.
within the city itself.
Correct, but this was made part of the record. I'll just read out.
It wasn't.
We can
Where was it
give
made
you
part of?
liberty to make a representation.
And government can consider.
Since you have appeared, at least we have to. Huh?
This intra-court appeal,
Public. This intra-court appeal has been filed challenging the judgment and order dated 7th of March 2022, passed by Learned Single Judge in WP number 367 of 2022 in bracket S that dash TR bracket close, whereby the writ petition challenging the transfer order dated 31st of December 2021 by the petitioner has been dismissed. No, disposed of. Dismissed. Dismissed. Para. Learned Vivek Subba Reddy, senior advocate, appearing for the appellants, submit that the Learned Single Judge has failed to appreciate that the impugned transfer order dated 31st of December 2021 was contrary to the transfer policy Moreover, it was based on extraneous considerations. Full stop. It is submitted that petitioner has not been given, the appellant petitioner has not been given liberty to raise his grievance against the impugned transfer order by way of a representation. Full stop. There are counsel for respondent number 2, 5. On the other hand, submits that the order passed by a single judge is just and perfect. It does not call for any interference. The appellant petitioner has been transferred within the state,
the city of
within the city of Bengaluru from Karnataka Power Transmission Corporation Limited to Bangalore Electricity Supply Company Limited. No prejudice has been caused to the appellant petitioner. Full stop. You will pay the cost of 10,000.
Should be waived, Lord.
That is for your benefit.
Correct.
It is not substantial.
We will reduce it. Full stop. We have considered submissions made by a counsel for the appellant as well as counsel for fifth respondent and gone through the record. It is an admitted fact that the appellant petitioner has been transferred within the city of Lucknow, city of Bangalore from the post of Deputy Controller of Accounts, Karnataka Power Transmission Corporation Limited to Bangalore Electricity Supply Company Limited in bracket BESCOM. The appellant has completed more than 2 years on the post of deputational post of Deputy Controller of Accounts. The transfer policy, full stop, the transfer policy is in the nature of guidelines.
Plus, division bench has said it has the force of law.
Leave that. The transfer is an incidence of service. The appellant petitioner cannot insist to remain posted on one particular post. Full stop, since the impugned transfer is within the city, no prejudice is caused to the appellant petitioner. Full stop. In view of above, we do not find any infirmity or illegality in the view taken by learned single judge. The appeal as such is disposed of with the following order. The appellant, if feel aggrieved against the impugned transfer order, may make a representation to the competent authority within a period of 1 week from today. In case any such representation is made, the same shall be considered and decided by the competent authority in accordance with law expeditiously by passing a reasoned and speaking order. Number 2, the appellant petitioner shall join at the transferred place immediately without any further delay. The joining of the appellant petitioner shall be subject to decision on her representation as provided above. Full stop. The cost of 10,000 imposed on the appellant petitioner is made easy. The appeal is stand disposed of. Before this, you just where you have written the learned counsel for the appellant. In the last, say that the there is no reason for the court to have imposed cost of rupees 10,000 on the appellant petitioner. The cost may be dispensed with.
The AG for R1, notice to other.
Note the presence of all this.
Yes, that she has paid the money because 4 weeks was expiring, but let this order remain.
So then don't say this. Cost made easy. Don't say. When paid is paid. Already executed. Na?
17. Rajaram, please. Not intending to not. Suits for recovery of various are trying to not.
Mediation.
Shall we send it to mediation? Learned counsel for appellant as well as respondent jointly submit that the matter may be referred to mediation to explore the possibility of amicable settlement. Joint submission is placed on record. Parties are directed to appear before the mediation center on end of April.
After 1 week.
After 1 week date.
28.
28th April.
Co-direction कर दो.
The mediation center is directed to submit a report within a period of 6 weeks from that day, 8 weeks from that day.
List.
Relist June 2nd week date.
नहीं होगा पूरा ना.
8 weeks are on date.
जून जुलाई होगा.
July 2nd week.
स्टे करना पड़ेगा. स्टे करना होगा. कोई एंट्री मॉडल
नहीं.